Well, are you resting your case?
Other than these items that we have to put in, we've got ID in the video that we just saw, for ID purposes and some motions.
Well, are you resting your case?
Other than these items that we have to put in, we've got ID in the video that we just saw, for ID purposes and some motions. Yes, sir.
Anything to rebut?
No rebuttal, Your Honor.
Okay. All right, ladies and gentlemen, the jury, that completes proof in the case. Tomorrow morning at 9 o'clock, I'll charge you on the law that applies to this case, and then the attorneys will argue the cases to you, and then you'll begin your deliberation. So I'll excuse you until tomorrow. Try to keep your mind in an unbiased posture. Try not to hear or read, see, or tell anything that comes to mind. I'll see you later.
All right.
Patrick Donna here.
Did number 38?
And then Lewis K.
39?
And then Jesse Palmer.
40?
And then, Your Honor, I've got, just make sure we've got a complete record here. I've got the volumes 1, 2, and 3 of Michael Barrett, which is the full version without any, as it was taken.
Be 41.
And was this already?
I think that's number 31, already ID only.
Okay, 31.
I think that's all the exhibits we had.
Okay, plaintiff?
We're now going to enter your
Yes.
depots on your own.
We have video, what do you call it, thumb drive? Yeah, we have thumb drives. So we have Baxter, which should be 41.
Okay.
40.
No, 40 is Palmer.
Okay.
Then we have Turk,
42.
then Comstock,
43.
Baker,
44.
Barrett. Now, if I can just inquire of our IT man, Jason, those are just the clips. So these are the clips from volumes 1, 2, and 3 that were played to the jury.
45.
And then we have Mazaluskas, and it is in a black thumb drive, so it was hard to write on. So if Marion can label it somehow, that would be good.
Okay. Be 46.
And if I can inquire, Your Honor, the grid that was used for the various depositions that were done, for example, Mr. Barrett, in order to identify the pages and lines of the objections, and then you wrote your rulings, is that part of the record?
Probably not, but if it isn't, we'll make it 47.
So I think that all of those should be part of the record. Does
Yeah,
council agree?
I think my assumption was that those would be almost like the order, as though you had issued an order
Right.
on our motions or whatnot. So yeah, that's fine. Whether it's an exhibit for identification or an order.
We'll make it 47. Brian Deal.
And all of these videos are by ID only, right?
I've provided physical page copies of the 6 photographs that were from the Oprah show and the 1 photograph from, I think, Entertainment Tonight from when we were in the courtroom here. I provided those to Marion so that they could be marked and used because they were only shown on the screen.
Okay. Collected 48.
And the last thing was something we talking about in chambers about midway through trial, about the videos from last Thursday afternoon and how they would be handled.
To train, for example, clinical depression. There is lay testimony that Ms. Andrews felt depressed, but there is no medical evidence to support a diagnosis of clinical depression. So we would move to strike that from the complaint for lack of proof. So that one's the first part. The second part of this motion to amend has to do with paragraph 13 and the 25 enumerated, for lack of a better term, bases of negligence. I mean, they're labeled A through Y. Your Honor, they're duplicative, they're cumulative. Some of them have no basis under Tennessee law. I am happy to go through every one of them one by one. But frankly, you can group them together. So if you look, and if I'm going too fast, please let me know.
Go ahead.
If you look at, for example, B, C, P is in Pat, and S is in Sam, all of these have to do with a failure to train. It's 4 separate instances of a failure to train. For example, in B and C, it's a negligent failure to train its employees that safety is always first. Your Honor, I know of no duty under Tennessee law to train employees that safety is first. There's no case law that's ever cited that. There's nothing that indicates that a duty of care is to put safety first. It's reasonable care under all the circumstances. Under C, it's the exact same thing. Again, it's failed to train its employees carefully about guest safety and protection. And I highlight these two because they're endemic of what's throughout the motion to amend. It is a means of which they are trying to duplicate and multiply the various bases by just simply changing the words around or changing from active voice to passive voice. A good example of that is D&E, failure to protect Erin Andrews' safety before granting a request. And then E is you just flipped the situation. They granted a request that endangered Erin Andrews. It's saying the same thing 2 different ways in order to try to put before the jury that they're actually 2 different things. That there's all of these acts that they have to answer. And I assume what this is leading up to is a proposed jury verdict form where there's 26 counts or 26 things that the jury has to answer yes or no to. When frankly, they're just restatements of the same thing over and over again. H&I, failure to hire extra people. I, failure to hire 2 security guards. Well, that's the same thing. If you're hiring extra people and it's 2 security guards, it's the same thing stated twice. So then we go, for example, and I'll come back to J, but staying on this topic, K, L, and O all have to talk about a reasonable steps, a reasonable person, safe and secure environment. All of that is reasonable care. You can say it 17 different ways. It's one statement, failure to use reasonable care. There's no specific fact in any of those in which they're saying this is an example of failure to use reasonable care. Now, there are those in here, and that's why I'm not going through every one of them. There's certainly some of those in here that they arguably are providing a factual basis for it, but in a lot of these, they're platitudes. So let me go back down to J. Negligently failed to use common sense. Common sense is not the standard of care. In this case, it's not the standard of care under the law. It's reasonable care. What would an ordinary person do under the circumstances? Common sense is not the law. So turning to the next page and the next few, we have V. Negligently informed Mr. Barrett that Erin Andrews was staying at their hotel. Mr. Boylett yesterday in his questioning of Mr. Turk affirmed for the defense essentially that the call was made to Marriott International. And I don't have the transcript in front of me, but I can find that citation where he asked an extremely leading question to Herman Turk, and Herman Turk said, yes, you're correct. Well, the question was, you would agree that the call to confirm the reservation was made to the Marriott International. The proof at this point is that the hotel, the two defendants sitting here, were not the party that actually confirmed it. And I know I don't have the exact citation in front of me. I didn't have time to find it in trying to get prepared for this during the lunch break. But I can find that to the extent we need to find it between now and tomorrow morning. X. Negligently failing to call Erin Andrews after it learned that Barrett wanted to room next to her, creating an unreasonable risk of danger to her. Your Honor, we moved to strike that because there's no evidence in the record to support it. There's no evidence that the hotel knew that Barrett wanted to be next to her, specifically knew that that was his desire. The evidence is that that communication, the only communication that's in evidence, that comment on the info line, never got to the hotel. Lastly, and I've gone a little bit out of order, T, negligently failed to secure the peepholes or viewports. There's absolutely no evidence in the record at this point that the peephole viewport was unsecured when Mr. Barrett got to Miss Andrews' front door, or that there was any failure on behalf of the maintenance department to do the maintenance that they did. The only indication of, I hesitate to even call it an inference, or evidence, is some inference that there's not a document proving it. But there's no affirmative evidence that it didn't occur. So again, just summing up, the clinical depression, that is something that requires medical proof. There's no such proof in the record. Many of these listed forms of negligence can simply be called out as cumulative. Some of them have no basis in law, and some of them have no basis in fact. So we would ask that they be stricken.
Thank you. Again, I have great respect for my colleague at the bar, but what we do is plaintiff lawyers are always worried that we haven't put in enough to cover our client in these pleadings. And so we'd be very careful about making sure we plead sufficient language so her case can get to the jury and not be defeated by a motion for a directed verdict. This motion was granted at the time it was made. They never even stood up and voiced any objection to it. Really, Your Honor asked me two times, as I recall. Did you say that? They never objected. What if, I can tell you this, we're not going to show the jury these allegations. We're not going to show that in the closing argument. We're not going to waste our time doing that. So they're never going to see these things. They're not, Your Honor's not going to give them to the jury. And I think it'd be a mistake to try to think about what all was proven in this case and what wasn't proven, and this strike something. That's just so difficult to do that. So that really addresses the words that he's concerned about, and whether something is fits in with the law or whatever. We're just alleging facts here to be extremely careful. And as to the depression part, Ms. Comstock said she was depressed. So I think this motion at this time is not well taken. It should be denied.
Your Honor, just procedurally, a motion to strike is best filed once the complaint's actually filed. They've never actually filed the Fourth Amendment complaint. Now that the proof is closed, that's why we didn't object. Under Rule 15, motions to amend are freely given. This motion was granted. The proof is now closed. Plaintiff has never filed their Fourth Amendment complaint. And so rather than it be deemed that we waived it, it's brought up now to say, look, they haven't filed it. That's why we haven't filed an answer, because we have nothing to which to answer. But before they even do it, let's just go ahead and address all of this.
Okay, the court will direct you to file your Fourth Amendment complaint overnight.
Yes, sir.
The court overrules your motion. Your entire argument is predicated on distinction between direct and circumstantial evidence. And juries are limited to find facts as they find them based on circumstantial evidence as opposed to what you have or haven't proved, or either side proved or haven't proved by direct evidence. Secondly, this is a complaint. In fashion in the verdict form, I will not allow 26 questions. The questions were the negligent, very short form. So, and so ruled this time. Next motion.
Yes, Your Honor. Thank you. At this point, we would like to renew our motions for directed verdict. I'm not going to re-argue them. So duty of care and foreseeability, superseding intervening cause. However, there are additional motions that have come up since proof has now closed. I would like to address those. And there are really four topics, but they combine in two ways. So I'll kind of argue these two at a time. The first one is the claim of agency and joint venture that is contained in the complaint. With regard to agency, that's probably the clearest one. Whether an agency exists under a contract is a question of law. Plaintiffs have not put on any evidence that the contract at issue, the management agreement between West End and Windsor, was ambiguous in any way, shape, or form. Paragraph 3.01 of the management agreement, which Mr. Kennard made an exhibit and questioned extensively about, contains an express statement of contractual intent that in no way, shape, or form does the managerial agreement create a partnership, a joint venture, or an agency relationship. There has been no evidence of any aspects within the contract that created it. As a matter of law, the court should find that agency simply does not exist, and because agency does not exist, West End cannot be vicariously liable for any actions or omissions attributed to Windsor. On a similar basis is the joint venture issue. Joint venture is an area of law similar to a partnership and involving vicarious liability. There are certain aspects of that the case law have recognized. They must have a common purpose. More importantly, there must be some combination of the property, money, and skills to serve that purpose. There's no such evidence of a common combination of property and skill between West End and Windsor. West End simply owns the property, retains this company to manage and operate it. End of story. There must be an equal right to control of the means and operations. Again, very similar on the agency aspect of it. There is no evidence of that. Finally, there must be a sharing in the profits and losses. There are no sharing of profits and losses under this management agreement or under the mode of operation between West End and Windsor. Now, I know counsel will stand up and go, yeah, but there was testimony about a percentage of gross receipts. Gross revenue is not profits. The case law in Tennessee looks in a joint enterprise to sharing of profits and losses, not revenue. Based on those two aspects, there is a lack of evidence in the record to support an agency relationship between West End and Windsor, or that this relationship formed the basis of a joint venture by which, under either legal theory, West End could be vicariously liable for Windsor's actions or omissions, and we would move for directed verdict on those two legal theories.
Your Honor, the first one is easy, I submit, with all due respect. It's a question of fact. It's a contested issue of fact. Was there agency? And, Your Honors, we've submitted the proposed jury instruction on this, and I think it hits it right on. In some cases, there is no question about it. The court can make a ruling as a matter of law that there was an agency, and reasonable people can't disagree. Here, the issue has to go to the jury because it's a question of fact. If you recall, I called Mr. Peskin, the representative of West End, and went through all those things about authorized, and I know the jury's wondering, what are you doing all that for? That is really boring stuff, but it had to be done to show the jury that they were performing a duty, Windsor was performing a duty for West End that had to be done. And that West End wanted them to do it, they authorized the agent to do it, and it's just a question of fact. The jury will have to answer the question, do you find that Windsor was the agent of West End? Yes or no? If they say no, West End's gone. If they say yes, West End is in. So that takes care of number one. Number two, what I'd like to do is just reserve that and let's go through the arguments on the jury instructions and give us some time to look into these points he's raising now. Because I'm really not, right this moment, the legal genius that somebody should be to argue against this particular motion. I'd just like to hold that if we could.
You're speaking of joint enterprise?
Joint venture.
Okay.
And I'd like to, they're not waiving their argument. I'd just like for the court to give us a little more time to look up some of these things he's raised.
Nothing further, Your Honor.
So, okay, the court overrules the motion on the agency question. That's for the jury to determine. It is a question of fact. The question of joint venture could be a question of law as well as a question of fact. TPI 12.30. And I'm not a genius either, but maybe I'm a genius law clerk. And you should look at the case of Fain versus O'Connell. 909 Southwest 2nd, 790. And off the cuff, I don't think the fact that gross profits or gross receipts really defines the joint enterprise. So I'll let you look at the law both sides. Next.
Judge, just for clarification, on the agency, are you ruling that the contract is ambiguous and the jury is able to analyze and get into the four corners of the contract? And is that what I'm understanding?
They can get into what was introduced in the proof. It's substance over form. You can say anything in the document. The question is whether or not there was a principal agency relationship, and that goes from the action of the parties. It doesn't have to be exactly on the contract.
But it's the ambiguity. I mean, are you making a ruling on the ambiguity of the contract?
I'm making a ruling when I do good. I'm ruling that the various factors of agency or principal can exist without words in the contract saying we're not agents or principals.
Okay.
All right, last motion, Your Honor. This one has to do with the claim for negligent infliction of emotional distress and severe emotional distress or severe emotional injury. And Your Honor, I'd like to start with the claim for the NEID. Based on the motion to amend, plaintiffs have dismissed their claim for negligent infliction of emotional distress. The only remaining claim against my clients in this matter is an ordinary negligence claim. By that very fact, in an ordinary negligence claim, no emotional, if you want to know, sure, I'll lead you through it. So here's the third amended complaint. If you have that, the motion to amend says, in granting of the summary judgment and blah, 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 it will be helpful to amend paragraphs 13 through 20 of the third amended complaint. We move that to delete paragraphs 13 through 20 and then substitute the following. And so what they have deleted is their negligent infliction of emotional distress claim. That is paragraphs 16 through 20. So the only claim that now remains in the operative complaint, having granted their motion, having denied our motion to strike, is an ordinary negligence claim. To support damages for emotional injuries in an ordinary negligence claim, you must have physical injury. Nowhere contained in the current applicable complaint is there any allegation of physical injury, is there any proof of physical injury. Therefore, they fail to state a claim and this matter should be dismissed.
I'm sorry, did you say in order to support a claim of, what was that again?
In order to recover for emotional damages in an ordinary negligence claim, you have to...
Okay, all right, I got you. Go ahead.
And that is Jones versus Marlowe Family Limited.
I thought you said something else. Go ahead.
Okay. So there's no allegation of physical injury. There's no medical expenses. There's no future medical expenses. There's no legal fees or out-of-pocket expenses. There's testimony here about those were incurred, but there's no proof of them. There's no amount. There's no claim in the operative complaint that those are being sought. The only damages being sought in the operative complaint are for emotional distress. But having dismissed the NEID claim, emotional distress without physical injury cannot state a claim. Therefore, we would ask that this matter, again, be dismissed. With regard to the serious emotional distress, serious emotional injury, to the extent that that claim has not been dismissed, which I don't see how it can when their own motion says they're dismissing it, would be a renewal of our previous directed verdict in which there is no evidence of a serious mental injury as defined by the case law. That requires something that an ordinary person would be unable to cope with. Dr. Brown, the only expert that has testified in this matter, has indicated that she is capable of coping and has a minor case of PTSD. Therefore, they have not met that prong of an NEID claim to the extent that they even have one, which, as we've noted, they do not, having dismissed it. So therefore, again, we move that the entire case be dismissed.
Okay, Your Honor, in paragraph 14 of the motion to amend the complaint, is this allegation: as a direct, proximate, and legal result of the aforesaid conduct and omissions of defendant West End and or Windsor, plaintiff Erin Andrews has suffered and continues to suffer serious mental injury and horrible mental anguish and emotional distress, including various things: sleep, depression, anxiety, crying spells, emotional outbursts, etc. And in paragraph 15 of this motion to amend, it says the plaintiff sought medical treatment, was diagnosed with a medical or psychiatric disorder, suffered post-traumatic stress disorder and or adjustment disorder, had clinical depression, and she suffered significant impairment in her daily functioning. These problems continue through the day and will in the future. These are all allegations totally consistent with negligent infliction of emotional distress. In the event that doesn't cover it, Your Honor, I move to amend the complaint to include old paragraph 20, the one he's complaining about, to make absolutely pure certain that this is part of this claim. We do make that amendment now, put paragraph 20 back in there. That's what they think is the problem. We move to amend to be certain there's a negligent infliction of emotional distress claim in this case.
Okay, overnight, I allow you, under Tennessee law, which grants liberality to motions to amend, especially to conform to approve, to rerun your complaint. Over next motion.
That's it, Your Honor.
Anything for the plaintiff?
No, thank you.
All right, have you submitted the special request to us yet?
I've sent in 6 so far, Your Honor. And if we could have a break, we can keep working on some
You
more.
can, and let me know, I'll come back maybe say in 45 minutes.
Thank you.
Okay.